and you're going to be facing that 10 years that I just gave you. So I didn't give you up to 10 years. I just gave you 10 years in prison. If you violate this probation, don't come in and start negotiation for something less. It's 10 years. All right, sir, are you Dustin Drake?
Yes, ma'am.
And Mr. Drake was previously in court. You entered a plea of guilty to driving while intoxicated, third or more. I've received the pre-sentence report. Has everyone had an opportunity to review that report?
We have, and we have no objection.
Yes, Your Honor, we reviewed it.
And there was no agreement. Mr. Lane, you may proceed.
Thank you, Your Honor.
When you hear a judge calmly confirm a fifth DWI, you already know this isn't about one bad night. This is about a pattern, years of chances, warnings, and people praying the next arrest wouldn't come with a body count.
I guess in situations like this, the PSI pretty much laid it out. So, I don't know if Mr. Drake can be any more sincere than he was. I think the PSI officer got that from him. Most of his allegations were DWIs. After this allegation, we know he entered treatment. He went through almost 18 months worth of treatment. He stayed sober. He's gainfully employed. He's moving forward. He knows that the court has a tough decision. I think he said it best in the recommendation where he was. I think he can be successful. His attitude's there, his groundwork is there, his mother's here, the foundation is all there to be successful.
Mr. Nichols?
And look,
Judge, this is his...
I don't doubt the treatment was real. 18 months sober is not nothing. Employment, structure, family support, that matters. But here's the uncomfortable truth. Courts don't just measure who you are now. They measure the risk you still pose to everyone else on the road.
Nichols?
Judge, this is his fifth DWI conviction, not counting two that were dismissed somewhere along the way. I left, when we formulated this plea offer, I left it as a count one plea to limit some exposure, but I think pen time is where we're at. I get, and I'm glad that there's what appears to be sincere attempts at getting treatment and doing all that, but the fact is, he hit a car. This night he was 0.27. Luckily, no one else was hurt. And I just can't fathom letting him back out on the road, Judge. So I would urge the court to exercise the full 10 years.
That
Mr. Drake,
prosecutor's line hits hard for a reason. I can't fathom letting him back on the road. That's not anger, that's fear. Because this time he hit another car, and luck was the only thing that kept this from becoming a funeral instead of a sentencing.
Mr. Drake, other than what's in the PSI that you stated, do you have anything else to add?
No, I really apologize for what I did. I know it was wrong. I am an alcoholic, and I do believe I can finish the probation. I'm not gonna sit here and make excuses for my actions because there are none. My record speaks for itself. I'm embarrassed and ashamed.
And I appreciate that, and I appreciate you not trying to make excuses.
This apology feels different. No excuses. No blaming stress or bad influences. Just embarrassment. And that's the tragedy of addiction cases. Sincerity finally shows up when the system is running out of patience.
And I appreciate that you've gotten treatment. The time for treatment was before your fifth DWI.
I agree.
You know, you've had every opportunity since, it looks like, 05, 19, 2021, well, 09, then 10, maybe. Anyway. I guess part of what I'm looking at right now is that there was a short probation from Louisiana some years back, 6 months. But other than that, there's never been, you've just gotten time, correct?
Yes, ma'am.
Okay.
When the judge
here's
says
what
the time for treatment was before your 5th DWI, that's not cruelty. That's accountability. Treatment after consequences isn't prevention. It's damage control.
Okay, here's what I'm going to do, Mr. Drake, and I hope you take advantage of what I'm about to do. Just based on several of the factors, the age of some of the history, the fact that you've gone into treatment already, I'm going to give you an opportunity, but you're not going home today. So here's what's going to happen. I'm going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time find you guilty. Sentence you to a term of 10 years in prison, but I'm going to probate that. You'll be on probation for 10 years. I'm ordering that you pay a $2,000 fine, and I'm ordering that you follow all of the rules and conditions of probation. The first one of those conditions is that you're going to enter and successfully complete the SafeP program. It's a 6-month in-custody program. It's the longest and best we have, and so at least that gives me some knowledge that you have some further treatment and some long-term treatment. When you're released, you will go through the JCDI program as your outpatient follow-up care, which is an intensive outpatient treatment. You will be required to have an auto ignition interlock device on any vehicle that you drive. I'm also going to order, at least for some amount of time, at the, I don't know how long, but you will be ordered to wear a scram device as well. That is a device that is on your body that shows if there's any alcohol in your body. If there is a positive sip of alcohol, your probation is going to be revoked and you're going to be facing that 10 years that I just gave you. So I didn't give you up to 10 years. I just gave you 10 years in prison. If you violate this probation, don't come in and start negotiation for something less.
This sentence is brutal in the smartest way possible. 10 years. Not up to. Not negotiable. Sitting right there. Waiting. One drink. One mistake. And the door slams shut. Scram monitor. Ignition lock. Custody-based treatment. This is a court saying, we believe in recovery, but we believe in public safety
For
more.
something less. It's 10 years. Do you understand? So you'll have the scram, the auto ignition, SafeP, JCDI, and any other conditions that probation deems would be important for you to be successful. So this wasn't an agreement. You do have some rights to appeal. I'm handing you the trial court certification. Well, it shows that y'all waived the right to appeal on this. So
That's because we did have an agreement.
you did have an
to go on
agreement.
Count one, Your Honor.
Correct. So you have waived your right to appeal because the state made that concession that they went forward on count one only. I've also handed you the trial court certification or admonishment that shows that that because of the judgment entered against you, you're ineligible to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term. You should read the written admonishment I provided you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Lane. Obviously you're going into custody, but I am ordering as a condition of that probation, it's mandatory 10 days upfront time. So you'll get that credit while you're waiting on safety. All right, you can go back with the bailiff.
I'll go run.
Yeah, go with the bailiff.
Thank
This
you,
is
Your Honor.
mercy
Yes,
with
sir.
teeth. Not forgiveness. Not trust. Just one final opportunity. Under a microscope. And honestly, that may be the only kind of mercy that still saves
You'll
lives.
just email the attachments to the clerk. Good morning, you're Ray No,
Good morning, ma'am. Yes, ma'am.
and will your client waive the formal reading of the indictment in each case?
He does.
Just a second. Figure out what today is. Sorry, can you get in there? Mr. No, in cause number 25, DCCR 0386, you're charged with the second-degree felony offense of intoxication manslaughter with a vehicle from December 11th of 2024. And how do you plead to that charge?
Guilty.
And y'all have marked here aggravated. What is,
Defense counsel put that here.
Yeah, well, they charged it as aggravated with a vehicle, I believe. It was aggravating.
It's just a garden variety intox.
yeah, I'm going to mark that out because I think that might
Feel free,
have
Josh.
some
Different context.
context at sentencing that you may not want. All right, so it's, how do you plead to that charge?
Guilty.
And are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you actually did what they've charged you with?
Yes, ma'am.
We're sorry it's gonna be a trial.
Sorry, give me just a second to get to the other one. And And then in cause number 25, DCCR 0387, you're charged with the state jail felony offense of driving while intoxicated with a child passenger from December 11th of 2024. And how do you plead to that charge?
Guilty.
Again, are you pleading guilty freely and voluntarily?
Yes, Your Honor.
And are you pleading guilty because you did what they've charged you with?
Yes, Your Honor.
In each of those cases, I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Franklin?
Yes, Your Honor.
Do you fully understand them?
Yes, Your Honor.
And do you understand that it's first of all, it's the way this is written up is that you are pleading open to the court. There's no agreement. Is that correct?
Yes, Your Honor.
And so you guys, a couple things. I need the other one sent back. So is it on the trial court certification of defendant's right to appeal? On this case, the state jail, the admonishments were signed saying that they're waiving the right to appeal. And then on the certification, it's actually 2 of them were checked off. One is the defendant has waived the right of appeal, and the other is it's not a plea agreement and the defendant has a right to appeal.
It's not a plea
It-
agreement,
Right.
so that's correct.
Okay, so with everyone's permission, then I'm going to erase these check mark on the defendant has waived the right of appeal because it's not a plea, so he will have some right to appeal.
Yes, Your Honor.
No objection.
Also, on each of the paperworks on the post-conviction waivers that you both signed, I will mark that out as well because that's saying that he's waiving his right to appeal.
Yes, Your Honor.
Okay,
Objection.
all right, thanks. So,
Your Honor, I would note too, I think I had a few stray, I'm a left-hander. I think there's a few other stray marks on there that
Okay.
I tried to erase and wasn't able to. So
Gotcha.
if you see those, I apologize.
gotcha.
But my hand
We
taps.
understand the left-handed issues up here. Ms. Werner feels your pain on that. Okay, so I want to make sure you understand a couple of things. You have an absolute right to have a jury come in and determine 2 things in these cases. The first would be to determine if you're guilty or not. And then the second would be if they find you guilty, you could leave your punishment up to that jury. If we go forward this way, you're waiving that right and you're leaving your punishment up to me in each of these cases. And is that what you want to do?
Yes, Your Honor.
All right, state tenders number 1 in each case.
No objection, Your Honor.
It's admitted. Also, sir, do you understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?